Hi, my name is Rhynn Evans. I'm a paralegal in the Consumer Protection Unit here at the Delaware Department of Justice. I'm joined by George Lees and Chris Curtin. George joined the DOJ in October of 2018. Prior to joining the DOJ, he was in private practice in the state for 21 years, litigating a broad range of matters in all of the courts of the state. While in private practice, he was involved in numerous matters representing automobile dealerships, including sales and warranty disputes. So Chris is the first common interest community ombudsman assisting members of residential common interest communities, such as condominiums, cooperatives, and planned residential subdivisions to understand their rights and responsibilities. He was Delaware Today magazine's top lawyer in consumer protection in 2013 and was the first deputy attorney general appointed to represent the Division of Consumer Affairs full-time. He returned to the DOJ in 2014 after a career in private practice focusing on consumer protection, consumer fraud, civil litigation, and investigation of complaints for local government ethics commissions in Delaware and Maryland. So we are here today to talk about the Lemon Law statute and auto issues in Delaware. So as a broad overview, the Lemon Law statute talks about what happens when a new automobile doesn't conform to a manufacturer's express warranty. When a consumer reports the nonconformity during the first year or the term of the warranty, whichever is earlier, the manufacturer must fix it. Now, manufacturers are required to make a reasonable number of attempts to conform the vehicle to the manufacturer's express warranty. Under the Delaware statute, 4 or more attempts is considered a reasonable number. If they've attempted 4 or more times to repair the nonconformity and it's still not where it needs to be, the manufacturer either needs to replace or to refund the vehicle. There's a couple of other points to be aware of if the vehicle is replaced or refunded. The manufacturer can keep what the statute calls a reasonable allowance to allow for the consumer's use of the automobile and a reasonable allowance for damage that isn't attributed to normal wear and tear. But of course, this is a very broad, very general overview of the statute, and that's why we have George and Chris with us today, is to go over some more specifics. So I'm going to kick it to George. George, what types of vehicles are covered under the statute?
Sure, because right out of the gate, the statute itself includes some very precise definitions, and one of them is what's covered. It's an automobile, and it goes on to talk about passenger motor vehicles. So that really looks at how does the Division of Motor Vehicles or the state classify vehicles and whether it is a passenger motor vehicle or not. So included in that definition will be things like your cars, your pickup trucks, a sport utility vehicle. Motorcycles are included. Motorcycles did not used to be included, but in 2016, the law changed and motorcycles are now included. Because motorcycles are included, certain types of scooters, which are also registered as motorcycles. Scooters, when I say scooters, don't think of the scooter that your child rides on with their helmet and that they push. It would have to be a motorized scooter over a certain horsepower or engine displacement would be included. Motorhomes are also included, but there's some requirements or limitations on motorhomes. For example, the motorhome, the parts of it that make it a motor vehicle, the brakes, the transmission, the engine, things of that nature, would be included in the motor vehicle. But the back part of the motorhome or the part of the motorhome that has the sink, the toilet, things of that nature that don't really relate to the operation of the motorhome as a motor vehicle aren't included. One of the things I learned as I was preparing for today is truck tractors or tractor trailers are not included in motor vehicles because they're not personal motor vehicles. So it really comes down to what type of vehicle you're talking about and how it's going to be used and how it's in fact registered in the state. The other thing to keep in mind that is not included is while motorcycles, people say motorcycles generally, what they're talking about are your motorcycles that have lights, horn, turn signals, motorcycles that are registered for use on highway. What's not included are your off-highway vehicles, whether they be your UTVs or side-by-sides, your four-wheelers, and motorcycles that are designed principally for off-road use would not be included within the Lemon Law. So I know one of the things we're going to talk about, and I'm actually going to defer to my colleague Chris on this one, because this is really more of his area of expertise, is just because a vehicle isn't covered by the Lemon Law doesn't mean that that's the end, the inquiry, or your rights end at that point.
Yeah, that's a great point. Chris, can you talk more about some of the other claims that can be made in that instance?
The Lemon Law, as has been discussed so far, is a specialized purpose warranty law, and it's designed to minimize disputes over the types of vehicles that George just ran through. It creates bright line standards that other warranty statutes don't have, like the 4 repair attempts in the first year, and it has some other bright line standards. But there are different warranty statutes. Most commonly used, and most commonly used even in Lemon Law litigation, is the warranty statutes under the Uniform Commercial Code Sales Act. There's a series of express and implied warranties that are statutory, and they're much broader than the Lemon Law. The Uniform Commercial Code, instead of having bright line standards, asks the same questions as the Lemon Law, but it wants to know what's reasonable under the circumstances. The Uniform Commercial Code is also supplemented by the federal Magnuson-Moss Act. It's a federal statute that supplements state warranty statutes in important ways, like that it make it possible to have a recovery of attorney's fees from the plaintiff's point of view, to pay the plaintiff's attorney for winning the case. The Magnuson-Moss Act also allows more types of damages than the Lemon Law. The Lemon Law focuses on the purchase price and the financial aspects of undoing a sale, but the Magnuson-Moss Act also allows slightly more vague damages, like damages for aggravation and inconvenience of the owner, and loss of time or out-of-pocket expenses for finding substitute transportation and things like that. A third category of statute that I generally use in Lemon Law litigation is the Consumer Fraud Act. The Consumer Fraud Act is another general consumer protection law without the Lemon Law's bright line standards. It allows recovery of punitive damages in certain circumstances where the proof supports finding the intentional or negligent misrepresentation of facts in connection with the sale or advertisement of the automobile. And there's usually plenty of that to be found in preparing for the Lemon Law case. Does that take care of the other claims?
Yeah, I think so, Chris. Thank you. That's really helpful to know that there's other claims there at work. So one thing I did want to ask you too, so consumers may not know that there's a number of things that need to happen prior to filing one of these claims. One of those being a pre-suit investigation. Can you talk about what goes into that investigation?
Mostly the pre-suit investigation involves the consumer collecting information that they've been provided during the sale process. They have to gather together all of their sales agreements, the purchase, the financing agreement, the warranty booklet, of course, because it's a warranty-based action. They have to get the owner's manual, which has very much important stuff about how to use the vehicle and to use it properly and how to maintain it properly and when to take it in for repairs and where to take it for repairs. And all of that's going to be important at some point and have to come in through one or another witness. Collect sales literature at the dealership, the glossy brochures of cars in action and in beautiful setups, people having fun riding down the highway with the wind blowing in their hair, that kind of stuff. So the sales literature is great. I also have recommended, and when cases come to me, before I file suit, I check the internet for video of any of the year, make, and model of my client's car to see it in operation in advertisements prepared by the manufacturer. I like the consumer to try and first get the first round of repair orders from the dealers. I like to send the owners back because it's easier for the owners to make the request. They get access to the full copy of the work history of the vehicle. And what I'm especially looking for is what the dealership calls the mechanic's hard copy. The mechanics take their will work on the last page of the multi-part form, and it's usually a card stock, and they write their notes in pen on the back of it. And if you don't ask for it, you don't get it. You don't see it as part of your sales package, but cases are won and lost on what the mechanics are saying about what's going on with a particular vehicle in many cases. I suggest, and if it's a case that comes to me, I order from the Division of Motor Vehicles what's called a certified title history. A certified title history shows the entire history of the car on a single document that is a state document prepared in each state on government requirements. And it shows it from the date of manufacture to the delivery to the transport company, to the delivery to the first dealer. And sometimes, more frequently than I expected when I first started doing it, you'll find that the dealer that sold the car was not the first car dealer to get it. And the first car dealer to get it was willing to trade that one because it was a lemon. And so there's more work history papers that you need to get from that any other dealer that had its hands on that vehicle. Once all of that documentation is gathered, I think that's an appropriate time to either meet with a lawyer or to draft a demand letter to the manufacturer demanding repurchase of the vehicle, since the Lemon Law is aimed at manufacturers and not dealer liability.
Hey, Chris.
Yeah.
I'm going to jump in for a second. When you were working your side of the cases, I know you did the plaintiff side and I did the defense side. When you worked your side of the cases, would you get things like service bulletins and look for manufacturer recalls as well as like consumer reports or the Consumer Product Safety Commission to see if there's known problems or things that are being either reported voluntarily or involuntarily by manufacturers that would impact your litigation?
All of that. And I would paper my file with not only consumer reports, but the TSBs, the technical service bulletins directly off the internet from the National Automobile Safety Institute. And I would typically have a consultant, usually a mechanic and usually a different mechanic for every case, help me evaluate what was right and what was wrong without doing and sometimes having a full inspection done by our own inspectors.
That's really helpful to know. That's a huge swath of documentation. I think probably most people aren't aware that they need to collect, and there's a lot of information there. On the investigative side of it, that's part of what what you need to collect, and that's just part of the process. So the other side of that being what you actually need to prove. So Chris, can you speak more to that?
Yeah, I think you actually hit a lot of it on your opening. The statute is pretty clear that you have to prove that it's a new motor vehicle, that it's covered by a manufacturer's warranty, that it has a condition that substantially impairs its use, value, or safety. And I know that George is going to be talking about that later, but the Lemon Law uses a slightly different standard for this category of proof than the Uniform Commercial Code. The Lemon Law has pretty much what the lawyers call an objective standard. What would a unimpaired person in similar circumstances think about whether this particular condition impairs the use, value, or safety?
That's really helpful to know. I want to shift gears a little bit and talk about nonconformity, which Chris, you mentioned a little bit, talking about what you need to prove. So nonconformity in the statute means a defect or condition which substantially impairs the use, value, or safety. Now, substantially impairs carries a lot of weight there. George, can you speak more to that?
Sure. Well, obviously, I know you just read it for us. And even as a lawyer, that is the most lawyerly sentence you can ever have, because it doesn't really tell you what it means. It tells you this is the standard. And then you have to try and figure out what that standard is, right? Because it doesn't tell you. It doesn't lay out like it does in the other parts of the statute that Chris just talked about, where you've got to come in 4 times or it's got to be out of service 30 days. It doesn't have that level of definition that's otherwise contained in the statute. So how do we figure out what that means? You have to look at the cases. And the cases themselves talk about it impairs the use, value, or safety of the automobile. And it then talks about a 2-part test. The first part, or the first test that's applied, is look at the circumstances. And so it's very factually driven. So no 2 situations are ever really the same. At least that's been my experience. A problem with one car doesn't repeat itself with the next car, because if the manufacturer has that, they recall the vehicles. So you really dealt with a case-by-case approach, or a case-by-case analysis, that even when it's the same type of vehicle, and I'll pick on Yugos because they're no longer manufactured, right? But even if it's a Yugo, the problem from Yugo to Yugo may not be the same. So you have to really look at each individual situation. The second part of the test is whether the car has, or the vehicle has been in fact impaired. Now, things that will be considered: has the vehicle been rendered inoperable? For example, the engine won't run, the car won't shift into gear. Every time you go to stop, the brakes burst into flames because they're superheating, things of that nature. Or is it something where the car can still be used and be operated as a vehicle? So when you start getting into the factual inquiries, and these are the things that, quite frankly, Chris and I would fight over, because we're on opposite sides of this, right? Is how often or how many miles has the consumer still been able to drive the car? If you're still driving the car every day to and from work, and from the time that you bought it until the time you make a claim, you put 15,000 miles on it, as a defense lawyer, I'm going to argue that's not a substantial impairment, because you're still able to use it every day. Is it something like a tire pressure light being on nonstop? Well, that's a specific case where the court said that's not a substantial impairment, where the TPS, or the tire pressure system, is malfunctioning, and you've got that annoying little yellow light on your dash the whole time, every time you get in the car. It's annoying, yes, but it's not a substantial impairment. So the great thing is, as I was going through this, preparing for today, I did look at where the courts have said there is a substantial impairment. And what amazed me is the number of cases where Chris is the attorney of record in each of these instances. And I unfortunately didn't show up. I guess my clients listened to me when I said this is a case to settle. And so, for example, a substantial impairment is when the check engine light is on, the engine hesitates and bucks unexpectedly, the vehicle's in for repair 5 times in the first year, and the vehicle's out of service for 38 days in that first year. And that was a case that Chris had against Mazda, where he prevailed because there was a substantial impairment. An issue where, for example, the car vibrates or shakes at high speed. There was a dispute about whether that could in fact be repeated or duplicated. There was experts on both sides. Well, in that case, the claim wasn't substantiated, and the court didn't find that it actually substantially impaired the value of the vehicle. And that was a case against Mercedes-Benz. There was another case where, again, it involved the Mercedes-Benz. So here again, you're talking about the same manufacturer like Chris and I were mentioning, but a different issue. And this is one where the first motor that came with the vehicle, it had a cracked block. And so the manufacturer, at its expense, replaced the motor. They may not have been very forthright with the customers when they replaced the motor, because the customer thought they were getting a new motor. Well, what's a new motor? For Mercedes-Benz, that meant a short block, meaning that they send the motor with the pistons and the crank and all the bottom end, but the intakes and the top end of the motor, they reused from the old motor. To a customer, they don't know the difference. They hear new motor, they don't realize it's only part of the motor being replaced, not actually the whole motor. Well, after that first new motor was put in, the vehicle continued to have problems, and it was overheating and everything else. Well, that ultimately was found to be a substantial impairment. And what was interesting in that case was ultimately the manufacturer did not, they offered to put another new motor in, and the consumer refused because they said, look, we're not happy you didn't give us the honest answer the first time when you only put a short block or just part of the motor in. Plus, it's continued to be a problem. It's been overheating. The overheating caused damage to the motor itself. We want a new car. And in that instance, Chris actually prevailed for his client against Mercedes-Benz and got a new vehicle. So it really comes down to, how is it impacting or affecting your use as a consumer of the vehicle? If it's something where you're not able to drive it every day because it overheats, it breaks down, it leaves you stranded on the side of the road, it's in the shop. Those are the things that the court's going to look at during their very fact-intensive inquiry of whether it substantially impairs the vehicle. The biggest thing that, quite frankly, seems to really cut against consumers is if it's something that's a nuisance or annoyance, that's not going to substantially impair it. If it makes it unsafe, if it causes the vehicle to turn off, not to be able to drive, not for you to not be able to enjoy and use that vehicle, that's going to be a substantial impairment. That's the type of thing that the court's going to look at and say that the vehicle is of little use to you as a vehicle. Those are my thoughts on what constitutes a substantial impairment. It really means that in each and every case, it's going to be looked at individually. And if the car is problematic and it can't drive, the bigger the problem operating the vehicle, the better your chances of recovery.
Really helpful. Thank you, George. And thank you both, George and Chris, for the time you guys took today to talk to this. I do think we may have lost Chris, but very helpful nonetheless. Well, thank you all for your time and for watching. Please check out the rest of the series for National Consumer Protection Week, and have a great day.